Cool. Just, I'm not sure who all in here has been on one of my webinars before, but I generally have webinars that vary in complexity. This one's not overly complex, and it's kind of more for H-2B beginners. So we're going to be talking about the H-2B visa program. I'm going to do an intro, some application. We're going to talk about seasonality. By seasonality, I'm actually going to refer to several different types of need in the H-2B program. Then we're going to talk about just some ongoing compliance risks, some recent rule change, and then something that we're seeing come up more often, particularly as it relates to DUIs or any kind of other criminal offenses. And then we're going to get into some questions at the end. So one thing to know about us is we service at Farmer Enterprises, we service employers in a whole bunch of different industries. We leverage the H-2B program a lot. So we're really familiar with the different types of justifications for temporary or seasonal need. We do everything from the recruitment, worker processing to the immigration work. We service companies, again, a bunch of different industries: food manufacturing, landscaping, hospitality, construction, you name it. Those are the ones that we do a whole bunch in. The way that we work is we work from the beginning to the end. So we work from the very initial legal strategy side to the filings, to the recruitment, to logistics, document translation, compliance, worker processing, follow-up, everything like that. So it's a complete in-house solution, and H-2B is just one of the many tools that we have available. But it is a really great one. It's one that I love a lot. It's a fun program. It's very useful and very impactful for the employers that use it. A lot of people ask about the different countries that we recruit and process workers from. So a lot of our recruitment is in El Salvador, Mexico, Costa Rica, Guatemala, South Africa. We've processed country in a bunch of different countries, and one of the recent rule changes with H-2B really opened up the access to folks in different countries. So there was an eligible country list before December, and then the final rule went into effect in January. So now they did away with the eligible country list. So it's pretty open. That doesn't mean that you can actually effectively get workers from any country, because one thing that we see is it varies by country on the actual approvability at the consulate, which is a discretionary approval at the consulate level. The best thing that you can do if you're starting to use the H-2B program is to not try to go with some country that wasn't on the eligible country list before. If you can avoid it. And the reason being is because the consulates themselves have to learn how to process these applications. And that can be tough, especially in any volume. So if you're adamant about getting workers from a particular country, that's fine. It's technically doable. But you're going to be better served by going to the countries that have regularly processed H-2B workers. And here's a handful of them here. So from a compliance perspective, we try really hard to educate our clients on compliance. Compliance is very important. The H-2B program in particular is pretty complicated from a compliance perspective. And so with all of our clients, we just want them to ask as many questions as they have with compliance, because we want to make sure that our clients are running a compliant program. At the end of the day, it's our client's responsibility to run a compliant program, but we try to empower them in every way that we can to actually be able to do that. And so if you want to see some of our free resources, you should go to our website. We've got a whole lot of content on there about H-2B compliance. But it can be kind of tough. And so I really recommend that whoever you're working with is someone that's very familiar from a compliance perspective and is able to offer you really good advice in how you can maintain compliance with your H-2B workforce, which is different than just if you're just recruiting people locally. So it does add a level of complexity with compliance. And so it's really important that you pick the right partner. Okay, let's talk about the H-2B program. The H-2B program's used again in a whole bunch of different industries. It's a non-immigrant visa for non-agricultural work. There's an agricultural equivalent, which is called H-2A, but they are different in a few ways. So with H-2B visa program, it requires a temporary or seasonal need. There's 4 different ways that you can demonstrate this. The 4 ways are what's called an intermittent need. Most people don't use those. I very, very rarely see them. A one-time occurrence need, a seasonal need, and a peak load need. A lot of people get confused or conflate what is a seasonal and peak load need. I remember a few years ago, well, longer than that now, probably 7 or 8 years ago, Department of Labor themselves, whenever people would file seasonal or peak load needs, they seem to be a little, I guess, not necessarily consistent in how they were applying those definitions, but then they changed that around 2018, 2019, where they became very consistent with what is a seasonal need, what is a peak load need. And it's important that you know what those mean going into it. And so the easiest way to remember it is a seasonal need is a need that you only need during a particular time of year. So there's certain circumstances where this would apply. Let's say that let's say that there's H-2B workers coming into a school district. Well, the school district doesn't need cafeteria workers in the summer because there's no students there. So, but they do during the school year. And so that's a perfect example of a seasonal need. Another example would be snow removal. You don't need snow removal in July in almost anywhere. But a peak load need's different because what a peak load need really means is that there's a certain time of year where you need more workers than the other time of year. So we see that one really often in hospitality and landscaping and construction and manufacturing jobs where there's a certain time of year because of some event that requires more workers. From a landscaping perspective, it's pretty easy to understand. It's whenever there's more growth. So fall or spring, summer, and fall generally. Plants go dormant in the summer, so you don't have to cut the grass nearly as much and things like that. So they need more workers during that time. That's how they leverage H-2B. There's a whole lot of ways of showing a peak load need. What's the purpose of the H-2B program is to address labor shortages. And by that, what we mean is this program is meant for employers who have a need for labor that the U.S. workforce is simply not meeting. One of the most important things to the Department of Labor is that employers don't use the H-2B program to harm or potentially harm the U.S. workers. So what does that mean? That means if you file for H-2B workers and you're paying them one wage, you have to pay the corresponding U.S. workers at least the same wage. That means that whenever you're going through the H-2B process and you file and put up your job posting, which is one of the requirements, then you can't just reject U.S. workers because you want the H-2B worker. You have an obligation to hire any able, willing, and qualified U.S. applicants that apply for the position, and that's something the Department of Labor takes really seriously. Another example of something that the Department of Labor takes seriously in an audit, and this comes up all the time, is let's say that you have a job order, and the job order says that I'm going to pay my workers $15 an hour. But you have these H-2B workers that have been coming for years, and you just pay the H-2B workers $17 an hour. Well, during an audit, what the Department of Labor would say is you only advertise the job at $15 an hour, and if you would have it at $17 an hour, maybe you would have got some U.S. workers to apply for the position. Generally, I don't think that really makes it's I've never noticed a practical difference in terms of the actual application rate for the higher end jobs and the lower end jobs. The reality is the people that are using this program are using it because they have to, not because they want to. And U.S. workers don't actually turn out for those higher paying jobs, but that is the Department of Labor's position, and they take it regularly in audits. It's very, very common. And from the employer's perspective, they don't think anything of it. They just think, I've got these H2B guys for a long time. I really like them. They've been really good to me, and I just want to pay them more. So they're not thinking on the other side is how will the DOL perceive this? They just feel like they're doing something good for their employees, and so it's one of those things in an audit that tends to rub employers the wrong way, but it usually, I mean, it comes up all the time. The H2B program is really great, though. If your company needs seasonal workers or temporary workers, and you can't fill that need over the course of your busy season, it makes a big difference for you operationally. And this gives you access to a workforce that's reliable, that's consistent, that's hardworking, that's driven, that's appreciative, that's not complaining all the time. And what we've seen is that there's very little turnover, and employers tend to bring the same people back year after year. So maybe they're training them in their first year, but the second year, the third year, the fourth year, the fifth year that they're in the program, it's the same people coming back year after year. And it's a really, really cool thing. From the worker side, it's really neat too, because it provides them an opportunity to work in the United States lawfully in jobs at wages that are otherwise unattainable in their home country. And I think that's great. It ends up having a huge impact on those people in the long run. So the H-2B program is capped annually at 66,000 visas per fiscal year. The government's fiscal year starts on October 1st and ends on September 30th, and they allocate those visas in two separate increments, both 50% each. So on October 1st, the first half of the fiscal year, there are 33,000 visas available. In the second half, there's, again, 33,000 visas available. That generally, in the annual budget bill, they will provide for supplemental visas, and those supplemental visas are generally allocated based off of the halves of the fiscal year, and then two separate sub buckets. One is for workers from specific countries. These are right now, it's El Salvador, Guatemala, Honduras, Costa Rica, Colombia, and I feel like I'm missing one. But there's a specific subset of countries that are given an additional allocation, regardless of whether the people that you're recruiting have come on an H-2B visa before. And then there's another sub-bucket called returning workers. And a returning worker is someone who has had an H-2B visa in one of the last 3 fiscal years. The cap can be a really confusing thing, and I don't really expect anyone to understand what I just said, but I think that the best thing that you can do from a strategy perspective is work with someone that really does understand the cap, has access to labor in multiple geographies, because it allows you to have a backup plan for if your application doesn't hit the statutory numerical cap of 66,000, which is very possible. It's possible in the first half of the year and the second half of the year. The first half of the year didn't used to be nearly as competitive as it is now, but I would expect for October 1st start dates for there to be more applications filed than there are visas available. And so I think that cap will get hit really quickly. And so a lot of employers are going to rely on those supplemental visas. And there's a whole process to this, but you need access to the people. That it's very, very important that you have access to the people, and working with the right person can make the difference between you getting workers and you not. And so I highly, highly recommend that you are working with someone that, one, understands the cap, and then two, understands how you can work within the framework of the new statutory numerical cap as well as the supplemental visas. Okay, so there are certain industries that we do a lot of work with: food manufacturing, landscaping, hospitality, food services, construction, transportation, industrial sanitation. Uh, there does tend to be seasonal needs, and I should say more of a peak load need because it's actually a temporary need, a peak load need for everything, including labor. The and it's not, the reality is that there are certain businesses that truly don't have a seasonal or peak load need. I mean, it happens all the time. So whenever that's the case, the H2B program is just simply not made for you. But there is an aspect to it where a lot of people just don't understand that they even have a peak load need. They know they're busy during certain times of year, but they think I'm busy all year. Like I would say that about my business is I'm busy all year. And if you looked at uh, but if you looked at my payroll reports, for example, you would see that I'm significantly busier from November through May or June. So my business would technically have a peak load need because of the number of immigration filings that go out during that time. But at the same time, I would say, yeah, I'm busy in July and August and September and October. I would say I'm busy during all those times. But that's not what it means by a peak load need. So whenever you're establishing seasonality, you need to be working with someone that actually understands these things and can extract the proper information from you to see if your company fits within the regulatory framework required by the DOL. Then let's talk a little bit about the application process. I'm going to go through it kind of quick, but it is about a 6-month process. And the process is, the first thing you do is you file a prevailing wage determination. This is called a 9141. And the prevailing wage determination what the Department of Labor does is they go and they reference what's called the OEWS wage rate survey in a particular area with a particular SOC code. All these things are important. The SOC code is based off of the job duties. So what we do is we talk to our clients and say, hey, fill out this job description for us. Let us know what the workers are going to be doing. The Department of Labor takes this information and applies an SOC code, which dictates the wages in that area by referencing their database. And that usually, the timeline for processing the prevailing wage determination varies considerably over the course of the year. I normally like to budget at least 60 days for that. And there are times where it's been longer. There's been a lot of times where it's a lot less. But oftentimes I think it's best to budget at least 60 days for it. At that stage, you're not having to prove seasonality or anything like that. You're just telling the Department of Labor, where are my workers working? What are they doing? And then the Department of Labor is giving you the proper wage rate. Now, remember, the wage rate that you use for your H-2B workers, you have to use for your corresponding U.S. workers. So let's say that I'm used to paying my U.S. workers $20 an hour. My prevailing wage comes back at $22 an hour, and I still have to proceed with the H-2B application. Well, I need to move my U.S. workers up from $20 an hour to $22 an hour. So getting the SOC code right is very important. And then the next stage during it, that you'll file, and you can file this part a maximum of 90 days prior to the date of need, is what's called the temporary labor certification. This is done at the Department of Labor. And at the same time, or maybe before, you'll file a job order with the state workforce agency. During the temporary labor certification phase, you will have to demonstrate your seasonality or your temporary need, whichever one you're trying to prove. And so you have to submit information to the Department of Labor to prove that. Through that process, the Department of Labor will issue either what's called a notice of deficiency or a notice of acceptance. A notice of deficiency isn't nearly as scary as it sounds. Usually, especially with first-time filers, they'll get a notice of deficiency because the Department of Labor is wanting to further evaluate the case to see, okay, let's dive in a little bit here. Look at the number of workers they're requesting. Look at the temporary or seasonal need. request information just to validate that it fits within the regulatory framework of the H-2B filing process. Very common. So whenever you respond to the notice of deficiency, the Department of Labor can either approve or deny the case. Let's say that they approve the case, then you'll go through the recruitment process, which is for 15 business days. During that time, you'll post a job, interview any referrals from the state workforce agency job posting. And at the end of that job posting comes down, you file what's called a recruitment report to the Department of Labor, and you will get a temporary labor certification. The only difference between what I was talking about is the next steps with the filing of the temporary labor certification is either you get a notice of deficiency and you respond to it, or you don't and you go straight to notice of acceptance. After that, you'll file a form with the USCIS called a Form I-129. And then that usually takes about 2 weeks to be approved. And once that's approved, you can start scheduling visa and consulate appointments. Again, the whole process usually takes about 6 months. So I would make sure to budget at least that much time for it. So understanding seasonality or temporary need is critical to H-2B approval. Getting it right is everything. This is one of the Department of Labor's favorite reasons to deny an application, and rightfully so, because it's within their regulatory authority, and that's one of the things that they're trying to determine. And so there's a lot of ways that you can demonstrate it. Your seasonality or your temporary need can be established through operational explanations, market-driven explanations, production-based explanations, weather explanations. There's a lot of things that can impact what it means to be temporary or seasonal. The keys to connect the business cycles with the labor needs, and the business cycles need to be dictated not by this is what I'm choosing for my business, but this external factor impacts my business, and it impacts my business cycle, which impacts my labor needs. So a lot of times employers will come and say, hey, I just want workers for these 9 months. Okay, why do you want workers for those 9 months? Well, I just think it's the best months to have workers. That's not good enough. It needs to be something that's based off of weather, market demands, travel, things like that just impact your business that are not influenced by you. So if you are a hotel, for example, in Nashville, well, you're very likely going to have an increase in your need during the months that aren't winter. Just not as much travel to Nashville during the winter. All the festivals, all the concerts, or a disproportionate number of them at least, occur during the warmer months of the year. And so you can prove this with various things, but you as the hotel don't impact the travel. The travel just impacts your business. And so, but there's a lot of ways to actually demonstrate it. There's even some non-obvious industries that may qualify if you are able to take an approach with demonstrating to the Department of Labor by explaining it in layman's terms why your business does have a seasonal or temporary need. The Department of Labor doesn't just say, okay, they said they have a temporary need or they have a seasonal need, good enough for me. And you can't, that one of the things that's important is to be able to break down your business to a level that a normal person can understand. Because something that might make sense to you as an industry expert in your particular business won't make sense to the person reviewing the application of the Department of Labor. And so whenever you're working with someone, you need to be working with someone that can actually understand that information, digest that information, and explain it to the Department of Labor in a way that does in fact demonstrate your temporary or seasonal need. So what we do is we collect documents and information that working with the client that demonstrate to the Department of Labor the client's true need for people based off of some external factors. So best practices for new employers: don't rush the process. And this, I know that this is a hard thing to say, because usually businesses don't think about their labor shortage 6 months in advance. But this isn't a process that should be rushed. Whenever you rush a process, things can go wrong. Uh, it might take longer than expected to collect information, even from your own internal systems. You're busy, and you're going to be asked to provide a lot of information to demonstrate that your application actually fits within the regulatory framework of the Department of Labor. And so it's critical to start early. You need to align with a trusted legal and recruitment partner. I cannot stress this one enough. Do not work on H-2B visas with someone that does not do it regularly. If you do, it's going to cost you a ton of money and it'll probably fail. I did not know this early on in my legal career, but H-2Bs have been have to me been one of the hardest visa categories to actually do and do right because of the speed of them, the complexity of them, and you have to be able to present this stuff in the way that the Department of Labor can digest it, which is not something that people can just fumble their way through. And on the recruitment partner front, it's very important that the people that you're using for recruitment hold a high ethical standard. In the H-2B world, H-2A world, the foreign national cannot be charged for anything related to getting the job opportunity. And there are a ton of foreign recruiters, a ton of foreign processors that don't abide by that. And that is something that is very, very important. It's one of the core elements of what we do. And I can't stress that one enough, because let's say that you're someone that brings in 25 workers and you don't know this, but you use some recruitment partner, and that recruitment partner charged those workers $1,000 a piece. And Department of Labor comes in and they audit you. And what they'll end up doing is they'll end up citing you for back wages to those 25 workers for $1,000 a piece. You as the employer, you didn't do it, but you paid a recruitment partner who did do it, and the Department of Labor can cite you for it. And so it matters. It can have a huge impact. It's important to educate your internal HR and compliance teams. Again, H-2 compliance is the responsibility of the employer. And so work with people who are willing and able to educate you on what does it mean to be compliant. And again, I encourage you to go to our website and look at some of the free resources that we have available, because it's a really good starting point. But for us, one of the things I always tell our clients is please ask questions, because I can't know what you don't know. And I can give you all this information, but it's something that you're going to have to ask for compliance advice, and it'll help you maintain a compliant program. Communicate clearly with workers pre-arrival, particularly workers that you have that are coming back. And I've seen it before where employers don't do any communicating with their workers during the off season. Whenever they don't, sometimes the workers just assume they're not coming back to work for that employer, so they go working somewhere else. And then that employer loses someone that they worked hard on training, really liked, really enjoyed, really had a good cultural fit, but they end up going somewhere else just because the employer didn't communicate with the workers before their filing process. It's also, from the worker's perspective, it's a very stressful event to go to the consulate, get a visa, travel to the United States, leave your family, come here and work for an extended period of time. And so it's just a good way to ensure that the workers that are arriving are doing so comfortably and consistently. So there's been a few changes, actually quite a few changes as of December. This is one of them that we saw. So with the H-2B visa program, workers are required to depart from the United States for an uninterrupted period of 60 days every 3 years. Now, sometimes we have employers who will say, oh, great, so I can have my H-2B workers for 3 years. Well, maybe not. It depends on the nature of your business. and your justification for temporary need. But regardless, even if the workers are going from one employer to the other, every 3 years they need to leave the United States for at least 60 days. And one of the frustrating things about this is that the the government's travel records are usually not very good. Like they won't document whenever the workers leave the United States. And so what we always tell our employers is to prepare for this. So whenever the worker leaves, have them go in their home country, the day they get in their home country, maybe have them go to a doctor, have them collect a receipt for a purchase that they had, and go ahead and send it into you and to add it to their case file so that you can prove that they were gone for those 60 days. Because if you don't, it can slow the I-129 approval process. It can result in requests for evidence on your I-129s or even potentially denials if that information is absent. So it's an important one, and it's a frustrating thing because it's just because of the government's internal systems that it's not documented on the government side to begin with. But the burden of proof does become on the employer. And so I always recommend that they do some of these things whenever the workers get back to their home country, just to ensure that there's no issues for their rearrival. This is also something else that we have seen recently. There's been new enforcement trends, particularly related to DUIs or DWIs, even without a conviction. And what happens is maybe the person got a DUI last year, or maybe they got it one this year, and they're on an H-2B visa. We've been seeing a lot of Department of State notifications via email to the employees that their visa has been revoked and they need to reapply for the visa before reentry. The employers haven't been copied on these emails. It's just gone to the employees. But it's also not just for DUIs and DWIs. We've seen it for all sorts of criminal offenses, even some pretty mundane things like speeding tickets. And so some things that are important are to educate your workers on legal consequences, support the workers with awareness materials. If they're driving, make sure that they only go the speed limit, that they're aware of the laws and rules here that relates to driving. Make sure to have a really strict no driving while intoxicated policy, just so that they know this is something that we take very seriously as well. And just really work on informing your workers of the potential consequences, primarily visa revocation for any criminal offenses. So it is important, and it is something that we run into quite a bit. All righty. So this is a couple questions that I see pretty often. One of the employers' questions are often, how can I qualify if my payroll shows temporary or seasonal need? Or the best way is to send it to someone like us who actually knows how to analyze payroll data. It's important to note, though, that payroll data is not the only thing that you can use to justify a seasonal or a temporary need. You can also justify it with things like sales reports, revenue fluctuations, hotel occupancy reports. Also, there's a lot of ways to skin that cat, and oftentimes it's not reflected in the payroll because employers will have people on the payroll even during their slower time, for example, where they're just keeping people busy so that they're prepared from a labor perspective for whenever it gets busier. And so Department of Labor almost always requests payroll records, but it's also not the only thing that's important for being able to demonstrate temporary or seasonal need. So again, you got to work with someone that really knows what they're doing to have a good shot in the H-2B world. Here's some information on us. If you have questions or want to have a follow-up, you can just email us at intake@farmerenterprises.com, or you can give us a call right there. You can check out our company websites and our LinkedIn pages. There's a lot of good content on all of those, and so I recommend going to all of them. Let me stop sharing this. I'm going to go to Q&A here. If you have questions, go ahead and put them in the Q&A. So the first question is, can you list the countries again that have a different cap? Sure. Yeah, it was that the ones that I mentioned were, let me just look them up real quick for you. Okay, it's El Salvador, Guatemala, Honduras, Haiti, Colombia, Ecuador, and Costa Rica. Okay, so I missed a couple of them there. El Salvador, Guatemala, Honduras, Haiti, Colombia, Costa Rica, and Ecuador. Yeah. This question is, does the 60-day rule apply to both H2A and H2B? Yes, it does. That was part of a new rule that came out in uh, December and then became effective in January. And I would, if you haven't, I might have done a webinar on it. I think I did a webinar on it. And if I did, I would go watch that webinar because it had a lot of information related to that rule, and that rule changed a lot of things. Uh, like the 60-day rule used to be the 90-day rule, and the 90-day rule used to be really complicated to figure out. So they kind of made that easier. It changed some stuff related to immigrant intent and filing an I-140 for an H-2 worker, which was important. It changed some things on the I-129 where you have to disclose prior DOL violations for the last 3 years, and gave USCIS some discretionary denial options for employers that either fail to disclose that or if they think that the employer might do it again, basically. So there's some really important stuff in there. I would definitely go check out that webinar. All right. If we don't have anything else, I appreciate everyone coming, and y'all have a good day.